Thanks, Nikos. As Nikos said, I'm a board-certified construction lawyer and have had the opportunity to deal with lots of different claims over the course of time. And the purpose of our webinar is to talk about a few things. What is a claim and why does notice matter? Procedures for giving notice for your claim, and best practices for documenting a claim after giving and receiving notice. And then we'll have some time for question and answer after the presentation. Next slide, please. So what is a claim? It's, as the slide says, it's not just for money anymore. We see lots of different types of claims come across our desk on the various different types of projects that we're involved in. Everybody knows that claims often involve time. They often involve money. They can also involve changes in plans, changes in the specifications, force majeure situations like what we've been dealing with recently with the COVID-19. But there's, as you all know, there are lots of unexpected issues that arise on a project, and the purpose of this presentation is to help you identify what those types of things are and how to make sure that you properly notice them. As you can see from the slide, the claim doesn't always have to involve money. There are lots of different things that that change over the course of time that you need to be prepared for and notice the appropriate party when it does. Next slide, please. What is a claim? Most of you on this presentation are probably familiar with the AIA form documents. Many of you all probably use them from time to time in your projects. And they are a great set of documents that have lots of definitions and defined terms. And so what we've done here is we've taken a section of the AIA 201 general conditions that gives a really good definition of a claim. And so it's defined as a demand or assertion by one of the parties seeking, as a matter of right, payment of money, a change in the contract time, or other relief with respect to the terms of the contract. And keep in mind that this is what the AIA defines as a claim, but it's not necessarily what your contract defines as a claim. So we'll probably hear this several times during the course of this presentation, but read your contract. Make sure you understand what a claim is, and it may or may not be documented in your contract, but certainly the AIA gives you a good starting point. Importantly, the AIA says that the responsibility to substantiate that claim rests with the party making it. That's the last bullet point. And so always keep that in mind when you're trying to figure out what you're going to do when something unexpected arises on the project. Odds are the contract's going to speak to what you need to do, and it's going to be your burden or the other party's burden to make sure that they notify of that claim. Keep in mind that the claim also could mean your lien and bond rights. And this presentation is not meant to cover lien and bond rights under the various 50 states. But keep in mind that there may be a claim that you have for a lien or on the bond, that there are very strict timing requirements that are not set forth in your contract that you need to pay attention to. Also, keep in mind what a claim, the difference between a claim, a change order, or a modification. The AIA documents speak to what a change order is, and that's a written instrument prepared by the architect and the owner, stating the parties' agreement on such things as time, additional money, and the extent of those adjustments. And so oftentimes a claim, if the parties agree to it, will be memorialized into a modification to the contract or a change order. But the process typically gets started with one party letting the other know that there is some change that they need some relief for. Next slide, please. So you have a claim. What do you do now? So that's where, going back to the point, always read your contract. Know what the provisions in the contract say about providing notice of the claim. Most good contracts that we review have a person to whom the notice is supposed to be sent and where the notice is supposed to be addressed, the business place of the party that you're giving notice to. And how long do you have to give that notice? Most contracts, most well-written contracts will have a period of time, 20 days, 5 days, 21 days. Make sure that you understand how long you have to provide that notice, because as we'll get into in a minute here, courts, particularly ones in Florida, are oftentimes not real lenient when you don't give timely notice. A couple cases that we've cited here where courts, one case, the Marriott Court, which is a federal court of appeals that governs here in Florida, the 11th Circuit, as well as the Tuttle White case, a first DCA case, which governs cases that are filed here in Jacksonville, Florida. Both of those courts denied substantial claims solely because the contractor failed to provide timely notice of them. Next slide, please. The Marriott case is an interesting one, where it was a fast track construction project in Orlando. I think at the time it was one of the largest by square footage in Florida, and there was defective concrete. There were lots of changes. Ultimately, the jury awarded this particular contractor $2.2 million in delay and other damages against the owner. Next slide, please. And that, next slide. Might have a little, thank you. Sorry, go back one, please. Thanks, Austin. The $2.2 million award was reversed on appeal, and the court said that the contractor never complied with the contractual notice requirements, and none of the contractor's verbal communications to the owner were sufficient. Next slide, please. Same situation in the Tuttle White case. We don't know what the dollar value of the claims were, but we know that there was a suit filed for contractual damages. The parties were operating on an older version of the AIA A201 general conditions, which at the time required notice of claims within 20 days of the event giving rise to the claim. However, all of the contractor's claims were made outside of that 20-day window, and the court said in that case that those claims, like in the Marriott case, were barred because they weren't timely presented to the owner. Next slide, please. So a couple things to keep in mind in a situation that you don't want to find yourself having to argue in front of a judge is, well, we gave you notice, we told you over the phone, or we had some email communications about it. You knew that we were being delayed. You knew that we were looking for more money, and sometimes those communications will suffice in putting the other party on notice. And these cases that we've cited here at the bottom, the Fletcher case and the Tuttle White case, in the dissenting opinion in Tuttle White, said that the party had actual notice of the claim because there had been discussions about it or constant communications about it. It wasn't necessarily in the proper form, or it wasn't exactly within the requisite time period, but everybody knew that this was coming, so it was sort of a no harm, no foul. Point being that on that, though, is those types of arguments, if you're in litigation, are very expensive ones. They're factual scenarios where courts aren't going to just allow a party to get out on a summary judgment type motion. It's going to require, in all likelihood, a trial, because at that point it's a he said, she said situation. And the point being of this is, don't find yourself in that situation. Follow the contract and provide your notice as the contract requires. Next slide, please. So we see this from time to time on projects where parties have very specific notice requirements. They have very specific anti-waiver provisions that do not allow the parties to modify their contract unless the modification is in writing. Those are all great and certainly need to be in all good contracts, but keep in mind that those provisions can always be altered by the party's course of dealing. So even if the contract says that all changes must be in writing, and even if there's a no waiver provision, the parties can, during the course of the project, choose to operate in another manner. And what that does is it means that everything going forward, someone is going to argue, well, that's the way we did it before, and you didn't have any problem then. Why are we arguing about it now? Another situation that you don't want to find yourself in litigation, because then you're having to argue what the party's course of dealing was, what the parties truly meant, and what they understood, all of which equates to very expensive arguments made in litigation, and you want to try to avoid that. Again, always follow the contract when handling and submitting the claims. That's your safest course. I know it probably goes without saying, but we see it from time to time. You just need to make sure you read the contract when it comes to these types of situations and follow it. With that, I'll turn the next part of the presentation over to Ryan.
Hi, good afternoon, everyone. This is Ryan Maloney. I hope everyone's enjoying their lunch and the presentation so far. We've heard from Joby how important providing contractually compliant notice is and what can happen to your claim if you don't do that. In my section of the presentation, I want to talk about, well, what does that mean to provide contractually compliant notice? And some of the key things that you're going to want to look at in your contract are, what the notice provision says with regard to timing, how long do you have to provide the notice, the manner of providing notice. Does it have to be by certified mail? Can it be by email? What types of notices are sufficient? To whom the notice needs to be provided. The contract may designate a specific person or persons who are the right people to send notice, and notice to somebody else may not be sufficient. And then what needs to be contained in the notice? Is the notice requirement such that the claim notice has to have substantiation and detail, or is it just a simple notice that can be supplemented later? So we're going to cover those things in my presentation. The slide here is, this is an example of the type of provision you might see. This is from the current AIA 201 general conditions from 2017, section 15.1.3 on notice of claim. And as you can see, this provision, one we've all seen, addresses some of these things. It requires that notice be sent to the other party, but also requires that notice be sent to the initial decision maker. And if the initial decision maker is not the architect, it also requires notice to the architect as well. It also contains a timing provision. 21 days, either the later of after the occurrence of the event giving rise to the claim, or 21 days after the claimant first recognizes the condition giving rise to the claim. So that second trigger may give you a little more leeway potentially, but it's also one that's going to be more expensive to litigate in court or in arbitration because it involves knowledge and recognition. So it's important, and as you can see here with this slide, and I think we've seen in some of the cases that Joby talked about, is you really want to make sure you've read your contract so that you know what all these requirements are and that you're doing it correctly and you're avoiding traps for the unwary. You don't want to get in a situation where you think you've provided correct notice, but you actually haven't, and then you're litigating those issues of prejudice where your claim is much more at risk than if you had provided contractually compliant notice. So an example of a potential trap that's out there right now in the 2017 AIA general conditions is section 1.6.1, which is the general notice provision in the general conditions, provides that the parties can provide notice by email if they so agree. And that's not an uncommon thing on a lot of projects, particularly in our modern construction industry, where a lot of communications are done by email and not formal letters. But what you have to watch out for is that email is fine for other types of notice, but for notices of claims under section 1.6.2, those types of notices have to be in writing and delivered by certified or registered mail or by courier providing proof of delivery, so a FedEx type delivery. So an email notice, while it might be appropriate and contractually sufficient under this provision for other types of notices, if it's a notice of claim, an email notice is not going to be sufficient. So that's just one of the things you got to watch out for, and make sure if it's a notice of claim, you're not relying on email, you're doing it like the contract says, or if on the front end, you may adjust the contract provisions to allow for email notice. And that leads to the next slide. I mean, one of the things you want to do, not only when you're on the project reading your contract, before you actually start the project, if you have the opportunity to negotiate some of the terms relating to notice, you want to take that opportunity. And what you want to do, it depends on where you are in the contract chain. If you're a contractor negotiating with an owner, well, you probably want your provisions to be a little more lenient on deadlines and waivers and those kind of things. If you're a contractor negotiating with a subcontractor, well, you may want to be more stringent. Similarly, if you're a subcontractor negotiating with a contractor, you're probably going to push for the lenient side. So these are some of the things you want to look at. I mean, generally more stringent are going to have clear, sort of explicit date deadlines, and they're generally going to be a little shorter. Whereas, to be a little more lenient, you might not want to have a firm deadline in there. You might want to have lengthier deadlines, like 20 days or 30 days. Some provisions that are more stringent will say things like, if the notice isn't timely provided within the time period, the claim is absolutely waived. If you're on the more lenient side, you're pushing for more leniency. You don't want to have that kind of language. You want to avoid that. And then finally, what has to be provided as far as substantiation. I mean, if you're pushing for a more stringent notice requirement, then you want to make sure that you're requiring detail and facts and substantiation. Whereas if you're on the side where you're trying to get it a little more lenient, you want to push for just a simple notice and then have some additional time afterwards to provide substantiation for the claim. But these are some of the key areas of negotiation that, if you have the opportunity, you want to take a look at and try to negotiate depending on where you are in the contract chain before the project even starts. So I want to talk in the next couple slides about practical tips for giving notice. And the number one practical tip is act fast. When an event occurs, a delay event or something that is going to give rise, or you think may give rise to a claim, the key is to make sure that you provide timely notice. And really, timeliness is the key here. You want to at least get some kind of notice out to meet the deadline. If you have to supplement later, you'd rather do that than to miss the deadline for not acting fast enough. So really, timely notice is the key. Another practical tip here is you don't want to be in a situation where you've had meetings or maybe you've had phone calls with other parties, the architect or somebody else involved in the project, and something said that you're relying on as to substantiate your claim down the road. You don't want to be in a situation where that's what you're relying on. You don't want a he said, she said about events, phone calls, meetings that could have occurred months or even years before the arbitration or litigation you're involved in. You really want to have things in writing, and really writing is the gold standard for us as lawyers in proving your claims. So, the best thing always, if something occurs in a meeting that gives rise to a claim, you want to send a contractually compliant claim notice. At a minimum, what you want to do, if you can't do that for some reason, if you have a meeting or a phone call, you want to send a follow-up email just confirming what was discussed, and you can do it in a way that's not too formal, but at least you're documenting something in writing that documents the occurrences at the meetings or on the phone calls. So one thing that I hear from clients a lot, and I get this, is that, hey, we don't want to be sending notice, formal written notice every time any potential thing might happen. We don't want to be seen on the project as kind of the bad actor that's claims centric and claims focused. And I understand that. I mean, you want to balance maintaining good project relations. And, there's oftentimes things happen on projects that get worked out. But what you don't want to be in a situation is where you don't send a notice because you think it's going to work out, and then things escalate and they don't work out, and then you're in a situation where you haven't sent the notice and you're trying to explain why you hadn't sent the notice, and your claim is substantially hurt by the lack of notice. So what I tell clients is, look, you want to make sure that you're providing notice when it's needed, but you don't have to make every notice a claim-centric, we're going to sue you type of notice. I mean, you can style the notice in such a way that the focus is on, look, here's an issue. We all want to work to resolve it. We're putting you on notice just to make sure, that we're covering our rights, but please let us know how we can work together to get this resolved. Focus on that kind of tone, and I think people understand, sophisticated parties in construction contracts should understand that claims and those kind of things happen when unforeseen events occur. But I think if you help balance that by looking at the tone that you're using, that can be an effective way to make sure you're preserving your rights while also remaining a good project citizen. So another practical tip, even after you've sent a notice, you want to make sure that as you go through in the project and you have a notice pending and maybe you have a claim pending, you want to be careful about what you're signing going forward with pending claims. If you have a lien release, for example, and the lien release releases everything up to a certain date, if your claim is involved with events that occurred prior to that date and you don't have a reservation of rights or some kind of carve out, there could be an argument that you waived that claim by signing that lien release. And that's the situation you don't want to be in. Another issue might be if there's a change order related to an event. If you don't have a reservation of rights related to other events related to those change events, there's a risk that you're releasing everything in exchange for that change order. And so you just want to make sure if you're signing something like that you really are covering everything. And if not, you want to make sure you're reserving your rights. Again, really the practical tip here is really read carefully everything that you're signing and be on the lookout for things that could inadvertently waive your pending claims. Finally, we talked a lot about the notice of claims and how important it is to be timely and do it in the right manner under the contract. But those things are also important when you're defending a claim. If someone's making a claim against you, you want to make sure that when you receive that claim, don't ignore it. You need to timely respond and put out your side of the story. You don't want to ignore it because you could be seen as sort of accepting or acquiescing to the claim, and that's something you want to avoid. And of course, if you get a claim that relates to somebody upstream, for example, if you're the contractor and you receive a subcontractor claim that relates to something that the owner's done or the architect's done, you want to make sure that you pass that through timely, and make sure that the owner's put on notice. For example, you don't want to be in a situation where you've received a claim from a subcontractor and maybe you don't think it's a valid claim, or you don't, for some reason, you don't pass it through to the owner, and then it turns out it is a valid claim, but you can't look to the owner because you haven't put the owner on notice properly under your contract. And that applies up and down the contract chain. So that's another important aspect of this. And then finally, if your contract has provisions about timely responding and making decisions on claims, you want to make sure you comply with that. If you're not following the contract and you're not timely responding and deciding claims, again, you could run the risk of later on arguments that you've acquiesced or accepted the claim by not timely responding to it and making a decision on it. So that's my section. I want to pass it on to my partner, Austin Calhoun, for the next portion of the presentation.
Thank you, Ryan. So what happens after you've provided notice or received notice? What's next? Now it's time to create, maintain, and organize documents to prove your claim. You don't wait till the end of the project to create the documents of proof. You need to create those contemporaneously during the project. The first step is to create a plan, to plan out what documents you're going to need. And it starts with knowing what you need, why you need it, and the best, most compelling evidence to prove that. So, at this point would be a good time to consult with your attorney. Ask what needs to be proved in order to succeed on this claim, and ask what is the best types of evidence that you should be creating and maintaining. And often overlooked are the other party's defenses. you may be thinking about your elements of your claim and what you need to prove, but the other party is going to have defenses. One example would be comparative negligence. That the other party was not solely at fault for the claim, that other parties were at fault. So how are you going to deal with that? What evidence will you create and maintain to deal with that? Walking through an example will be helpful to highlight the process, and so we'll use a delay claim here on this slide. But the process applies to any type of claim. So for each issue, you need to think through what, how much, and why. So for a delay claim, what? That's the schedule, the baseline schedule that the other party is contractually bound to. So what documents do you have to prove that the other party is bound to the schedule, including updates throughout the construction project? The schedule's updated, and so how do you document that the other party received those updates? How much delay? The critical issue is that the critical path was delayed by the other party. So how do you document that? Some examples would be what's called a fragnet, or a time impact analysis schedule that you create at the time of the event giving rise to the delay during the project, not solely after the fact. This would be a good time to consult with a scheduling expert, bring an expert onto your team during the project to contemporaneously determine the delay. Also consider using your daily reports as evidence. Courts look fondly upon daily reports, and they find them to be compelling evidence. And so state facts about the delay in the daily reports. Another element to a delay claim is damages. And so use that same thought process of what, how much, and why to plan and create your documents to prove damages. What type of damages are recoverable? You don't want to miss out on certain types of damages. How much damages were incurred? Why those damages were caused by the delay? You're only entitled to recover damages that were caused by the delay. So you need documents to prove that. And then so for each of these, the what, how much, and why, think through how you will document with the best proof. So one example would be in documenting the amount of damages, how much. Create separate cost codes. Track the damages arising from the delay separate, segregated from the other, routine costs and expenses for the job. And separate cost codes we see as a good method to do that. So you're on offense when you're making a claim, but you also need to be aware of defense. If someone makes a claim against you, that's a point where you need to develop a plan for documenting your defenses. And so it's the same thought process when someone makes a claim against you. Develop your plan of action for creating, maintaining, and organizing documents to prove your defenses. And last, I'll leave you with this checklist of proof. These are some types of documents that we find helpful that you should consider creating and maintaining during your project. And it helps to know how courts think about each type of evidence. Some evidence is more valuable than others. It's more compelling or useful in proving your case than others. For example, business records kept contemporaneously in the ordinary course of business, as opposed to something that you create for the purpose of proving your claim after the fact. The contemporaneous records during the project are often presumed to be more reliable than after the fact evidence. And before we go to the Q&A session, just want to leave you with 3 key takeaways. 3 things that if you learn nothing else, these sunk home. So be on the lookout for claims. Understand what a claim is, and that it often has a contractual notice obligation. Back in my day in the construction industry as a project manager, I can tell you this concept did not sink in. Us project managers weren't aware of the importance of the claim and notice procedures in the contracts we were dealing with, and could have easily fallen into traps for the unwary. Luckily, that never happened to me. Follow your contract requirements closely and timely. Like Ryan said, act fast. And then last, have a plan for creating and maintaining and organizing the documents needed to prove your claims. Know the legal elements of the claims that you're trying to prove. We all hope that you can resolve the claim amicably with the other party during the project and obtain a change order. But you got to plan for the worst. And in case that doesn't work out, you may find yourself in a lawsuit or an arbitration or a mediation, and you'll, at that time, wish that you had created and maintained the documents to prove your case. And with that being said, I'm going to turn it back over to Nikos to moderate any Q&A that you may have. Thank you.
Great, thanks, Austin. And just as a reminder for everybody, as we enter the Q&A portion, if you haven't submitted your question yet, you can do so. Upper right-hand portion of your screen, there's 2 comment bubbles. One has a question mark. It's kind of a purple area. You can submit your question there live, and we'll address it as time allows here. But for now, there's a couple of questions in the queue. Don't know which one of you guys want to take this, but it's, do I have to send multiple notices for continuing delay?
I'll take that one, Nikos.
Okay.
I would say, obviously, you got to read the contract, make sure you understand what the provisions require, but just in an abundance of caution, you probably don't have to continue to send notice after notice for the same delay. But in an abundance of caution, I would advise clients to regularly update that initial delay notice, reminding everyone that you're continuing to be delayed for that same issue. There's no downside to doing that. But if you're, depending on what the contract says, you're probably fine with initially notifying the party who's creating the issue or who you're responsible for giving notice to within the requisite time period of that first that delay starting, and that's probably sufficient.
Great. And then another one we have here is, when is it necessary to get an outside expert involved in a claim?
I'll take that one, Nikos. The sooner the better. When you get to a lawsuit, then you'll certainly have to disclose and involve an expert. But if you wait till then, that expert is stuck using the documents and scheduled data that you created on your own during the project. And we see quite often it's not always the best evidence, that the expert wishes that he or she had better evidence. Great example. See it all the time. Native format schedules that get overwritten during updates. So there's different ways for a scheduling expert to analyze delay. And the best way is to use native format version of each iteration of the schedule. So the original schedule, compare that to the next update, compare that to the next update using the native version. And contractors, I believe I was guilty of it too when I was keeping schedules, will accidentally overwrite the previous version of the schedule when they do a update. And so that can be avoided by getting an expert involved right away. As soon as you believe it could come, that the claim could arise into something that you'll ultimately want to pursue.
Austin, let me just add something to that. All great points. One of the things that you have to, it's a balancing act in terms of when to get an expert involved, because in many instances, the size of the claim doesn't warrant getting an expert involved, because the cost that you'll incur with the expert will be as great, if not more, than the actual claim is worth. So you got to make sure that the claim is one in which it's worth, so to speak, fighting for with an expert. Certainly we're involved in claims that are 6-7 figure claims. So that's, in my view, a no-brainer. You get a expert involved, whether it's a scheduling damages expert. You get that expert involved early on if you can. But if it's a smaller claim and you feel like you can get it resolved, or even if you don't get 100 cents on the dollar or 80 cents on the dollar on that claim, you may not want to hire an expert, just because for those of you who have never used a scheduling or damages expert in a construction related case, they're very expensive. They're very smart. They do a great job typically, but they don't come cheap. So it's a balancing act where you have to figure out whether the claim is one in which it's worth investing that time and money in an expert on the front end.
Great, thanks, guys. We have another question here, pretty timely given the situation out in the world today. But the question is, how do we handle supply chain issues due to COVID-19? And Ryan, I think you might be best to take that if you're unmuted here. So.
Okay, yes, I was on mute. Technology's great when it works. So yes, I mean, the issue with, if you're having supply chain issues where you're not getting, supplies that you're expecting to get, it's definitely a time when you want to look at your contract and potentially provide notice. I mean, your contract may have provisions known as force majeure provisions that are provisions that can potentially excuse the failure to perform due to certain types of unforeseen events. Not many force majeure provisions are going to say, worldwide pandemics, but they may have language that is sort of a catch-all language that could potentially apply to a situation like we've been dealing with right now. And you definitely want to make sure that if your performance is going to be affected by a supply chain issue due to COVID or whatever the reason may be, that you're putting the other parties on notice of that issue and in more of a defensive manner, that you're letting them know that this is the issue and why you can't comply, that it's not your fault, so to speak, and it's outside of your control. And so that's definitely a time frame when you want to put the other party on notice in writing and contractually compliant notice.
Thanks, Ryan. Is there anything that any of the presenters would add that hasn't already been said in response to any of these questions, or any of the other presenter sections that you'd like to get on the record before we close the session for today?
I've got a couple things to add, Nikos. Thanks. When we were talking about the section of the presentation dealing with the actual giving of the notice and receiving of the notice and how to react to it, there's been instances where, and probably everybody or many people on this call have been the subject of voluminous contracts where there are lots of forms and things that one party is asking the other party to sign in connection with getting paid or whatever the case may be. And those forms, they're great. And but I will tell you that you've got to be careful and make sure, if, for example, if you're a contractor and you're getting lien waivers or bond waivers from your subs, suppliers, that, you know, all forms don't look alike. And we've seen situations where a sharp subcontractor or contractor, or whatever the case may be, adds a little tweak to that form lien waiver, that form bond waiver that, you know, in a big project could get missed. And you got to be paying attention to those things, because you never know when someone who you think has been paid in full, and you think that they're agreeing that they've been paid in full, decides to alter a form that's attached to the contract, and they reserve a huge claim. You know, that works in two ways, that works both ways in terms of making sure that you reserve your claims. If you're providing lien waivers and pay applications and you're not including that language in there, then you can run the risk of waiving and releasing those claims. So I know we touched on it a little bit, but just be careful when you're dealing with forms that, you know, you're used to seeing and nothing really pops out at you. Take the time to look at those, because you never know what's lurking in there. And I can tell you that arguing those types of situations in litigation are very expensive, and situations that you want to try to avoid. And as I mentioned earlier in my presentation, we haven't discussed the timing requirements related to lien and bond claims, but make sure that if you have the ability to assert a lien claim, or you have the ability to assert a bond claim, depending on where you are in the food chain on a construction project, that you know and understand those deadlines, because those can be critical to making sure, or better ensuring, that you get paid for the work that you've done.
Thanks, Joby. Those are some great ads. A couple more questions. I believe we have some time for that today. We've got a question here that is in response to the supply chain, I believe. It's asking specifically, what about material that is already shipped and an owner wants that material returned, and suppliers are saying that they cannot be returned? The question is, they possibly do not want to pay for the material. What would your response be to that?
This is Ryan. So I can address that. I guess I'm assuming from the question that for some reason the owner doesn't want to proceed with the work in some way, that they want the material returned. I mean, I think that obviously on all this stuff, you're going to have to look at your contract and take a look at what rights the owner might have with respect to material that's already been paid for by you that you're unable to return. And if that's the case, I think you need to make sure that you put the owner on notice that the supplier is refusing to take it back, and the fact that you ordered it on the owner's, direction under the contract, and that, we want to make sure that the contract supports this, but that under the contract, the owner should be responsible to pay for it. Again, that's going to just depend largely on what the specific contract says, but that's how I would approach it without, having the contract in front of me.
Thanks, Ryan. And another question here, Mike Woods is asking, are you seeing or anticipating more COVID claims to use force majeure or change in government and law provisions?
I'll take that one. Yeah, we've seen people getting creative and making that argument, whether they're trying, and mostly when they're trying to extricate themselves from a contract or contractual requirements. And it's going to be, going back to what Ryan was just saying, it's going to be contract specific. Some contracts, most contracts that I've seen when we're looking at that issue recently, do not have language relating to pandemics and diseases and things of that nature when you're talking about force majeure. Now, is an act of God, or is a situation beyond the control of the contracting party? Is that a round peg in a round hole? I don't know. I mean, those are issues that the courts are going to have to decide on. But if your force majeure provision doesn't have something specifically related to a pandemic or a disease or something like that, you're going to have, it's going to be challenging. Because, like I said, most of the force majeure provisions that I've read lately don't have that specific language in it. Can you make an argument to fit within there? Yes, and we've tried to do that. in some instances, but it's going to require some people to take a hard look at their force majeure clauses going forward to include that language in there if it's not already. Because it certainly could happen again, and the best practice would be to take a look at that in all of your contracts, and to the extent that you want someone to have that ability to make that argument, it needs to be written in there to avoid any ambiguity or any question on it.
Yeah, the only thing I would add to that is that depending on where you are, if there's a government order that's forcing you not to be able to work and you're not deemed essential, such as in Florida, where construction has been deemed largely essential and exempt from those orders, even if the force majeure doesn't talk about a pandemic, it may refer to government orders or orders of governing authorities in some way, so that you may be able to argue that constitutes a force majeure event. But again, as we've all kind of said, and kind of the theme I think here is, read your contract, right? Because it's going to be really what is largely going to control. I mean, there's definitely law out there that's in addition to the contract, but the contract is always the first place you want to look, and the first area that's going to control how things are going to play out.
Great, thanks guys. Well, if there's nothing else, we appreciate everyone's joining us today and tuning into our webinar. This is going to be a webinar series the construction industry team is working on. So stay tuned for future installments as they dive into other topics specific to managing problem projects and what's going to be this new normal. We appreciate you all joining. If there are questions that we could not get to that you'd like to address to the presenters, their contact information is available on the Jimerson Burr website. That website is jimersonfirm.com. You can always call us for more information as well at 904-389-0050. More information about Joby, Ryan, and Austin is also available on our website if you'd like to reach out and connect with them directly. And as always, if you have feedback on today's presentation, feel free to send it to us at the link that you'll receive as a follow-up to this event. We appreciate your attendance and hope you have a great rest of your week.